Should I begin, sir?
Should I full screen it now?
Full screen. How?
On the screen you were sharing to me is, yeah, I have, it's full screen now. Yes, you can begin
Yeah.
it now.
Yeah, it is 6.
Yes, you can begin it now.
Yeah. All right. Good evening, one and all. It gives me immense pleasure that Dr. Paramjeet Singh has agreed to speak on our forum, Association of Indian Research Scholars, AIRS. We have been active since September 2020 and have successfully hosted eminent scholars including Noam Chomsky, Professor Joseph Nye, Professor Hargopal, Professor Rajan Harshe, Professor Zoya Hassan, Professor Afroz Alam, Professor Muhammad Mazam Ali, among many others. We have also released 2 newsletters which included not just webinar reports, but also opinion pieces by scholars from across India. If we have any piece you would like to publish with us, please consider sending us an email on our official email address. We are also available on all social media platforms, so please do connect with us, share, like, subscribe for updates and notifications. This is a special day for me as I am moderating today's session on such a relevant topic. My name is Zeba Tamkanat Moazam and I am pursuing my PhD from the Center for Comparative Literature, University of Hyderabad. Let me now introduce the speaker we have today. Dr. Paramjeet Singh is currently Assistant Professor of Cyber Law at Center for Postgraduate Legal Studies, School of Law, Presidency University, Bangalore. He has more than 10 years of experience in cyber and corporate law in MNCs like Infosys and teaching. He has completed his PhD from Punjab University Chandigarh in cyber law in 2020. He has presented many papers at national as well as international conferences. He has qualified his NET in the year 2013. I now call upon Dr. Paramjeet Singh to take over.
Thank you, Ms. Mozam. I would like to thank you, first of all, to the Association of Indian Research Scholars, uh, Ariba, you, everybody who's in the background, many of you I may not be knowing. Thank you so much for providing me this opportunity. Today, I want to talk about privacy law and the regulatory landscape. Not only in India, I want to talk about some other jurisdiction also, which are like USA, European Union. I want to talk about those also. So let me just open my files and start. So please shift to slide number 2, which is what is privacy. First of all, I would like to draw your attention to the notion of privacy. So what comes to your mind when I say privacy? If we go to dictionary meaning, it means seclusion, it means secrecy. So it's a kind of detonative definition which denotes the similar meanings. So synonyms are there, so we can make out what privacy is. Another way of defining it may be a connotative way where uh, we can define it by selective meaning interpretations, and meanings will differ with individuals. Everybody will interpret in a different way. So that is another way of defining privacy as far as the definitional part is concerned. So uh, the individuals define it the way they like, and I will quote Daniel Solo here as a definition to refer to. So he has classified privacy into 6 categories, which includes one. He says it is a right to let alone. So if you are an individual, you have a right to be away from the mainstream society for many of your affairs. And the second is the limited access to your own affairs. So it may be your relationships, it may be any other things which you want to restrict. Secrecy is one thing. There are some things which you want to keep secret. Another is that there is some information which you want to keep to yourself. That is another category. And there are some, relationships which you want to keep, which are intimate to you, which you want to keep to yourself. And then related to yourself. There may be something which you don't want to disclose to public. So broadly, these are the categories how where we can say this is something private to me. So I am going to slide number 4 now. Uh, so what continuing to as to what is a privacy. So it is something which permits individual to control the information about them. So I am talking about more about the individuals in my presentation today. Uh, Privacy is also related to organizations, but I'll focus on the individuals. And the other thing is that what values are served by preventing or limiting the flow of this information. So sphere of freedom of from law, legitimate law. So we'll discuss about how privacy and law are related. What are the laws relating to privacy? That we will come to in the second part of my presentation. Now, coming to a conclusion as to I'll go to slide number 5. So it's very difficult to define privacy. So everybody is it's like you are defining elephant and somebody is touching the tail and says it's like a long piece of wood. Somebody is touching the trunk, somebody is touching the ears. So it's just like that, and very rightly has been mentioned by Serge uh, in this definition that the concept of privacy is something elusive, and it is elusive because you cannot define it in a very concrete way. But again, as said, that if something cannot be dried and cut and put into a box, that doesn't mean that it doesn't exist. So I'll conclude that it's very difficult to define, but these are the broad parameters how we look at the privacy. Now, why it is relevant in the contemporary world is because earlier things were very limited. The information was flow was limited. Now with the advent of internet, this particular piece of privacy, which is the informational privacy, has been at stake. So if we talk about 10 years back or 15 years back, so privacy violations happened with the advent of technology like photography and telephones. Uh, these were the predecessor of the modern way avatar of communication, which we call as internet. Now, what is happening is that communication is. I'm shifting to slide number 7. Uh, Communication is instant. It happens within a fraction of seconds. The information which is going is profiled, is processed, analyzed, and the companies make money out of it. So that is the role of technology, which is hampering the privacy of individuals. Now coming to the second part of my presentation, which is talking about what is the legal and regulatory framework relating to privacy. Now, different countries have different kind of legal and regulatory framework. We'll start with the jurisdiction of United States. So I'm shifting to slide number 8. If you look at the broad framework of privacy in US, it's a sector specific approach. It's a sectoral approach, I will say. Every sector has a different kind of laws which exist. For this particular presentation, I would just restrict myself as an overview of what exists in terms of laws there. I will not go into very deep dive because I just want to give an overview of the overall privacy regulatory framework. So if we look at for example, the health sector, it's talking about Health Insurance Portability and Accountability Act is there in the health sector. If we talk about media sector, then it's video rental law is there. Then relating to child pornography, children online privacy protection rules are there, and like that. So they have sectoral laws for a different sector, a different set of laws. Similarly, they have different regulators for financial sector, FINRA is the regulator for that. So they will regulate every aspect of the financial industry, be it banking, be it non-banking financial institutions. And for other sector, there'll be for example, your pharmaceutical, so some other regulator is there. For example, this drug regulator, or, uh, and so it's a sectoral approach, I will say, and they don't have a centralized kind of mechanism where they have a authority which is regulating everything in this sphere. Then I would take your attention to the other part of the world, which is European Union. I'll shift to slide number 9. If historically, if we talk about the privacy issues in European Union, so privacy as such, the the tort of privacy or as a right, it never existed in the European society. Particularly, we when we are talking about the laws, we are talking about. My focus will be on England. So there was a for to quote here, there is a case of this Pollard versus photographic company. A photograph was taken. A photographer who has taken pictures of lady was restrained from exhibiting and selling the copies of it. And the the defense given was not that there is a privacy which exists for this lady. The defense was that the privacy, that there is a violation of a breach of contract. So indirectly, privacy was protected, but not as a right to privacy or a tort of privacy. But with the advent of this United Nations and the right to the human rights, the jurisprudence grew. So the right to privacy, it came into limelight. Then different kind of conventions and different kind of legislation, they started coming in European Union. The first which I can recall is that it is the European Convention for Protection of Individuals with regard to automatic processing of personal data. It came long back in 1981. This was just a starting of the computer age. Uh, the main object of the convention was to protection of the personal information of individuals. The personal information again here means that the information by which an individual can be identified. It may be his phone number, it may be his email ID, his photographs, anything by which he or she can be identified is the personal information here. Then I would shift to the next slide, regulatory framework, uh, European, the European Union. In the European Union, as far as the conventions are concerned, there are many conventions are there. I have listed a few just to illustrate what kind of framework exists there. Uh, the Convention on Cybercrime, it came somewhere in 2001. Then the predecessor of the current uh, piece of legislation, which is the General Data Protection Regulation, was the Data Protection Directive. For your information, just a basic idea about what is the difference between a regulation and directive. So directive is something which is a kind of guideline to the member states. You can deviate from the directives, you can tweak your domestic laws as per your own domestic conditions. But in a regulation, it's a stricter way to deal with the issues. It's a mandate. Now, why there was a directive earlier and why it is a regulation? The reason is that they came up with a directive in 1995, and every country created its own law to deal with the issues of privacy. Now, Spain had a different law, England had a different law, France had a different law, and there were conflicts of laws. For example, if there is a website which should be viewed by the adult members, then somebody will say my age of the somebody to be adult is 21. Somebody will say it's 18. So now there was a conflict. Now to deal with these conflicts, they came up with a regulation, which is the current avatar of data protection in European Union, which is a stricter law. There were other factors also behind this, because with the change of time, the circumstances changed. And for example, the concept of consent earlier, it was not taken very seriously as to if you are somebody who is going to submit some information, for example, say Facebook, you want to upload your photographs, then s- the processor or the controller of the information needs your consent. Otherwise, he cannot take the information from you. Now, the consent was not very seriously taken, and uh, companies were misusing the consent provisions. For example, if you are going to upload some information, you have to agree to the terms and conditions of the website, and then what they will do, they will just keep, already there will be a checkbox done. So once you say okay, proceed, you are impliedly agreeing to that. So these kind of things were done away with the data protection regulation. So consent was made explicit consent. You have to go and you have to agree to that. You have to do something to give your consent. It cannot be implied now, just like earlier it was. Another is there are another directives also which are still there and they exist. For example, money laundering directive, which requires the customers' due diligence records to be kept for at least 5 years. So that is an example of how the privacy is regulated by these directives. So there are a number of directives there. Just to illustrate here as to how these directives play a role in the regulation of privacy. And these are the basic legislation pieces of legislation or law, which I'll say is the regulations, directives, and conventions there. Then I'll take your attention towards the regional frameworks of privacy. So, for example, I'm shifting to slide number 11, where we are talking about, for example, Asia Pacific Economic Cooperation is trying to have a kind of framework. It's called APEC Privacy Framework. So this framework, they have developed some kind of principles. The first line of principles which were created for the privacy regulation were OECD principles. So these long back in 1980s, some set of principles were given by Organization of Economic Cooperation and Development. So these were very basic principles, just like consent, principle of accountability. You should be accountable for the information you are collecting. It should be used only for the purpose it is collected, and like that. And these principles have remained a very basic in the privacy jurisprudence. Still, these principles are a piece of almost every legislation worldwide. And they had issued these principles and guidelines in 1980, and they later revised it in 2000. Coming to United Nations, the role of UN in developing the jurisprudence of privacy. So going back to the basic UN uh, pieces of law, for example, the Human Rights Declaration or the, the the rules of the economic and social cooperation. So you will find that the right to privacy is the basic thing in human declaration. Again, if we look at the International Economic and Social Cooperation organization, it talks about uh, higher standard of livings and conditions of social and economic development of individuals. So without having a decent right to privacy, this is almost impossible. So if we look at very basic pieces of the UN right from the very beginning, you will see that the right to privacy existed, and it was always there from the very beginning. Now, coming to the next slide, we are talking about what kind of conventions or other forms of international law exist for this particular regulation internationally. So, just to illustrate here, I have mentioned a few conventions here. For example, the UN Convention Against the Transnational Organized Crime. So these crimes are basically organized crime in international sphere. For example, money laundering. Somebody is using the money in a way that it's hiding the source, and it's using for the illegal activities. For example, it can be terror funding or drugs or something like that. The other piece of is the Convention on Use of Electronic Communication in International Contracts, which is talking about uh, how the communication happens in international transactions. For example, the contracts. Then, for the purposes of giving the member states guidelines, United Nations Commissions on International Trade have given model laws. So these model laws, two model laws are there. One is on electronic commerce, another is on electronic signatures. The purpose is again what happened in European Union, that there were different laws in different jurisdictions, and there were conflicts. And internet and is something which is not restrained to any particular area or society or continent. So the laws have to be in sync with other countries, otherwise it will be very very difficult to punish and prosecute and deal with the violations of civil violations in international law. So they gave these guidelines, and they actually they drafted these model laws, electronic commerce and e-signature, so that the member states have an idea as to this is what how their law should be. So this is uh, these laws are recommendatory, and these are only for guidelines. And the basic objectives of for example, if we talk about e-commerce law, is to facilitate the use of electronic commerce and to provide the electronic information an equal treatment to as of we have to the paper information, just like a paper based contract is equal to the electronic contract. Another is to do away the obstacles in international trade due to the fact that these transactions are carried out electronically. The principles which I was talking about, the OECD laid down, I am shifting to slide number 15. these these are the basic principles which still are very very relevant and basic in this privacy jurisprudence. For example, the purpose of the principle of purpose limitation. So you can collect the information from anyone, any individual, for a purpose. If the purpose is achieved has been achieved, then you cannot keep that information with you. You have to destroy it, discard it, or give it back to the person. Similarly, consent, similarly, right to be forgotten. Everybody he can take his information back. You have to keep it secure, just like you keep your own information as good as it's your own information. You are accountable for the information you are collecting, and like that. So these are very very basic principles which are still very very relevant, and some issues arise due to various factors in implementation of these principles. Just to give you an example, uh, for example, the principle of consent. So if I want to take consent of, say, if you are uploading some of your photograph or some data on some social website, then the social website needs to give you a notice that we need your consent. This is for this purpose, and this notice which they will give should be adequate. It should not be that they just on the very corner of the website in a very small letters will write that uh, this is required, or they will give you some link which you will not even notice. So it should be adequate notice. It should be available to you. If there are some terms of reference, those terms of use or reference should be accessible. If there is a link to that, that link should be visible, should be adequately noticeable also. So uh, these issues did arise initially, and for that, these 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 remedies were given in different laws, for example, notice and all. Now, in the last part of my presentation, I will talk about what are the approaches to the regulation and overall approach to the regulation of privacy issue. So I'm shifting to next slide, which is 17. So one approach to regulate the overall structure of privacy law is centralized kind of regulation, which is talking about mandatory law. For example, we are talking about European Union structure. So GDPR, for example. GDPR is something, it's General Data Protection Regulation. So GDPR doesn't give you flexibility to make your domestic laws. GDPR is something which is a mandate for you. Now this is a mechanism, this is an approach which is centralized. Very little flexibility. States have very little discretion and uh, rigid kind of structure is there in this approach. The second approach to regulate is is very liberal, just opposite of that. I'm shifting to the next slide, which is talking about self-regulation. So this kind of approach will be that I give the freedom to, for example, I am talking about the software industry. So the association of the software industry, for example, it's NASCOM in India, will determine their own standards, how they want to regulate their organizations. They will develop the standards, they will enforce, they will have some, even NASCOM has some basic mechanism that exists. They have their standards, they have some kind of audit mechanism is also there. So let it give it to the organizations or the subject that how it wants to regulate. So this is the second approach to privacy regulation. And the third approach I will say is the mixed approach. So we'll look at how India is regulating, and then I'll just conclude that, and we'll try to evaluate and debate after the presentation as to what you think about how we are, in what direction we are moving into. So if we, I am shifting to the next slide, which is talking about the regulatory framework in India. So broadly speaking, we can distinguish the we can define the privacy jurisdiction in uh, two timelines. One is the very recent case of Puttaswamy. So pre-Puttaswamy is one timeline, that what happened to before that and what is happening after that. So pre-Puttaswamy is the privacy was not a fundamental right, but courts used to enforce the rights, privacy rights, through other rights. For example, long back in 1964, in case of Kharak Singh, the the privacy right to privacy was enforced under the Article 21. The words were personal liberty. So just to give you a background of this case, this individual was kind of a history sheeter, and there were domiciliary visits to his place by police people. So he had challenged some of the police rules of the state, and those rules were like police people can keep a watch on him, can in the midnight can inquire where he is and like that. So I would draw your attention to the next slide. Uh, how privacy was protected and how courts interpreted uh, the word personal liberty here. The court had held that is then, it's a question that is then the word personal liberty to be construed as excluding from its purview an invasion on part of police of the sanctity of man's home and an intrusion into his personal security and his right to sleep, which is normal comfort and a dire necessity for existence, even as an animal. It might not be appropriate to refer here the words of the preamble of the Constitution that has designated to assure the dignity of the individual, and therefore those cherished human values as means of ensuring full development and evolution. So they are not saying that privacy is a fundamental right. They are not saying that it's a right. They are saying that you have a right to personal liberty and you have a right, you your dignity and is protected by the Constitution. That's why we are uh, against these particular rules, and those rules were also struck down in this case. But privacy was not held as a fundamental right. So this position continued till the Puttaswamy case. Uh, Time and again, there were cases, and uh, privacy was protected, but it was not given a status of fundamental right. Now, in the next slide, I'm talking about the Puttaswamy case. It is privacy has been held as a fundamental right now after the Puttaswamy's case, and along with having it a fundamental right, there are other laws in India which are talking about uh, right to privacy, data protection, or we can say the biggest piece of legislation is the Information Technology Act, then parts of Contract Act and Credit Information Companies Act. Evidence Act also is talking about how to how how privacy is protected. So just briefly, I will touch uh, what are the basic ingredients of these laws. Information Technology Act 2000 is basically dealing with authentication rules, legal recognition, electronic transactions, security of electronic records, role of certifying authorities, e-signatures, offenses under the IT Act, and these offenses, just a list I will show you in the next slide, 23. So you can see here that this is the list of offenses under the IT Act: damage to computer system, tampering the computer resource, transmission of offensive messages, identity theft, stealing a computer device or resource. So identity theft, for example, is a uh, your mechanism to protect your privacy. If somebody logs in through your password and login ID and does something on the social media, that is called identity theft. So this is how your privacy is being protected by this piece of legislation. The another list is there in slide number 24, which is talking about cheating by personation, violation of privacy itself, cyber terrorism, obscene material in electronic form, access to protected systems, breach of confidentiality, privacy, and talking about misrepresentation. So these are some examples of the liabilities and offenses under the IT Act. Now, what I think in my presentation, I would draw your attention to the next slide. So what I think is that India is moving in a direction which is centralized, but not very strictly centralized. It's a mixed kind of structure, and we have industries like, just like I gave you example of NASCOM, that they are doing self-regulation also. There are sectors where very strict regulation is there, There are sectors where we are missing the regulation even. So we are not. This is my opinion, and this is open to debate, and we can talk about it. So my opinion is that we are a mix of the very strict and a very liberal kind of approach. And looking at the way forward, I will draw your attention to the next slide, which is talking about artificial intelligence. So right now we are talking about internet, communication revolution, and stuff like that. Now the next avatar of the communication revolution is artificial intelligence. For example, uh, Google Assistant or this Amazon Eva or something, I don't know exactly the name. So what these machines or these algorithms are doing is they are recommending you books based on what kind of books you have searched on the internet. They will suggest you the music, and a very simple example is just like YouTube one, the kind of stuff you watch in YouTube, it will automatically show you the more and more that kind of stuff. So artificial intelligence is the next future is artificial intelligence. And the laws, the regulations, the regulatory framework is right now everywhere is designed for internet communication, and there are issues which are arising. For example, uh, in future uh, we'll have self-driven cars. Even in India, in some part of the world, we have started, these cars have started being operational. And now if to give you an example, I'll say that if this kind of car hits and makes an accident, then who will be responsible? Is it the person who has, you know, coded the software of the car? Is it the manufacturer? Is it the internet service provider? So these kind of issues will be, the next kind of issues will be these kind of issues. And another is that internet of things, some people say it, that devices are being connected to each other, they will talk to each other. For example, your home, your office, and even if you are going for a picnic, all these places will be connected. You will able to know what is going to expire in your fridge. So again, different kind of issues will be there if these devices are talking to each other and one device makes a mess. So manufacturer of which device will be responsible, what data is being collected by which device, then being shared to another device, then who will be responsible if there is a breach of information, some data gets leaked. And these kind of issues are the next coming issues which we are not ready for right now. We are still thinking, we are uh, doing brainstorming right now, and future issues will be complex. That's what I see right now. With that, I end my presentation and I open the house for questions and comments.
Thank you so much, sir, for such an enlightening lecture on privacy and privacy laws. A few of the questions have poured in from in YouTube comments that we've put up. I'll just quickly ask one of these questions. Okay, so the first question that I see right now is this one, and that is quite fascinating as well. So it's slightly a theoretical question. It says, in the COVID world, we have invited the world into our houses and our living rooms. Do you think our understanding of privacy will change now, given this new era that we live in, the pandemic, in the pandemic?
Yes, definitely. Yes, I will say that right now, as we are talking to each other. So we are sitting in our homes and in our living rooms and talking to each other. So the understanding of privacy will definitely change. The reason being, I'll give you an example of this modern TVs. For example, this your Amazon Google Assistant kind of thing is attached to your television, and it can access the voice all the time. So even if you are talking, I'm talking to my family member, and I say something which this instrument recognizes, then it will give results. It will turn off lights or turn on light, stuff like that. So the issue is that my communication is going out through the internet. Everything what I am saying is going out. Now, who is responsible if that all that information goes out? That is the that is another another kind of uh, issue. So how much things I can keep private is another issue. So now if everything is going out, then who is who will safeguard it, and how much he will be safeguarding, how much he will be responsible for that. So the understanding of privacy will change. Right now we are just concerned about uh, right now I'm talking to you, so I am concerned about my communication with you. I know that my communication with you is online and it's being recorded, for example. It will be available to the public at large, but what about that kind of communication which I am not aware? Everything is going out. So the understanding of privacy is definitely going to change.
So with it, will the laws also change when the time comes? Is so how
Yes,
do laws then? Yeah. Okay. So the
yes.
next question is, yeah, how does privacy play out in a world of social media where privacy is particularly produced for public consumption? In this, what I think the person is talking about is how a lot of people are running this TikTok videos, right, where they are showing their own personal lives. For example, there are a lot of Chris and Ian. Karke, there's this one two cup. There's a couple, and they promote the idea of gay relationships becoming normal. And there are a lot of TikTok users of this kind who invite the public into their private lives of their communication with each other as a couple, how they express love to each other and things like that. So, and the other thing is that we constantly put up our achievements on social media, that has also led to the depression, that has led to depression among a lot of the young users, and also suicide in some of the extreme cases. So how does social media and how does privacy play out in today's world? Like, how does the law address these issues of privacy that are now becoming that are now being produced for public consumption?
So now, what I see in your question is two things. One is that uh, you yourself are showing to the world at large that you are talking about gay relationships or whatever you are talking about. You want to convey something to the world. So this is not strictly an issue of privacy. I will say this is an issue of ethics. This is an issue of what should be, in the mainstream, or what should not be in the mainstream. Because if you are concerned about privacy, then you will not talk about those things. So morals and ethicals are always, a part of law. And technology can help us. If law is there, then technology can help us. For example, if you talk about 5-10 years back, then this torrents and everything was so popular, and all the Hollywood movies used to get leaked on torrent. So everybody used to download those movies and see those movies for free. Now this was more an issue of ethics, I will say, more an issue of copyrights and all that. So this is how law has worked. The people came closer, and all the countries they joined hands. uh, your internet service providers or the regulators. They issued very strict guidelines that these kind of websites should not be freely accessible. Now, if you want to open a torrent website, uh, very it's very difficult. I won't say impossible, but uh, for a person like me, it will give a message that this website is blocked by the Department of Telecommunications. So technology is working with law, and that's how I look forward that these issues will be dealt with.
In relation to that question, there's one more question that came up, which asks that the moralistic notions of privacy that the state imposes may not be acceptable for the individuals of the state. For example, if they are specific points in social media where some people want to post up nude or semi-nude photos of themselves or certain genitalia, and that is considered a violation of privacy, right? But if the individual themselves want to put up these photos, so what does the law then? That's again a moralistic question, right? So how does the law then define what is private?
So how does the state reconcile the privacy concept with that of individual wants? So this has been always a point of debate in law that if we talk about sociological school, it says that the law has to reconcile here with the interest of the society and the individual. So just a very basic example, we say that keep left in India. I want to go on the right side. Now, uh, how would law reconcile it? Law will have to reconcile it because to maintain an order in the society, you will have to manage the traffic and everything. So if you will try to go on the right, the law will punish you. So this is the very basic notion of the reconciliation, but it's not as straight as I'm talking about. So if you are talking about uh, your individual rights, yes, you have rights, but subject to the overall interest of the society. So if something is is against the very basic notion of society, and again it's debatable. It's there that every society has different moral standards. So every society will have to define its standards, its morality and ethics, and as per that the law will take its course. uh, I can't be very I can't give you a very straight answer to that because it's a big debate.
Yeah, that's there. So, in relation to that question, there's one more that has come up. It asks that, now it's like the other side of the coin, like privacy is a complex concept. So, like for example, if in one part of the world there is some things are considered there is a possibility of public consumption, and in some places that it becomes something that is very private. For example, a few generations earlier, Muslim women would have considered it scandalous to take photos of themselves and paste it on legal documents,
Mhm.
for their passport or their ID cards for the government and all that. And given the kind of NRC and other laws that are coming up, this becomes very important, right? Because our grandmothers are now supposed to show photos and their legal documents of or the ID cards from before. And if they had chosen, this is a very hypothetical situation, if they had chosen not to take a photo or not to make any legal document because it was against their understanding of what is moralistically allowed and what is public and private, then how does a state juggle with this? How does the state create a law in which these people do not feel like they are be considered outsiders, or they how does the state reconcile with this?
So sometimes it happens that the society at large is not, you know, consenting to some kind of mechanism. Uh, yes, for example, taking photos, then making, you know, documents. So this is something where it's a very tricky situation where uh, I would say that, you know, the legislator should here take some kind of, you know, midway where, for example, photo is one thing, but if it is hurting any religious sentiments of any community, then they should come up with some alternative. For example, fingerprints can be something, and now we have all the technologies available. Fingerprints can be taken, saved in a chip, and a card can be made like that. So my suggestion here would be that you should take, you know, all religions and all uh, kind of members of the society along, and reconcile it rather than, you know, just sticking to something.
Thank you, sir. One last question, I think, that is related to this previous question, which says that this concept of privacy is a very modern thing that comes from the creation of the internal self that we see in the writings of the 18th century, and then it spreads through colonialism. And writers like Dipesh Chakrabarti and Charles Taylor have written on this. So the question is, how does privacy play out in our post colonial lives? Do we go forward with the universalized, uniform Western notions of privacy, or does the post colonial, marginalized world create their own notions of privacy and then this gets incorporated into the law?
Can you flash this question again to me if it is possible?
Yes, sir.
So I would differ a little bit here that it's a modern concept. Privacy is a modern concept. I would say that privacy is something which has existed since, you know, these societies came into existence. Maybe before that it was not there, but since the people started living with each other, so there was a sense of privacy in every community. uh, for example, we say that marriage is a ritual, is a custom, uh, or any other example. You have your own family, that is something you have, and it's your private affair. So I won't say that it's a modern concept, but yes, it has changed with the time. It was different in the pre-colonial time, it was different in colonial era, and it is changing right now in the post-colonial period, particularly last, I will say 20-25 years have been a very uh, fast changing in terms of privacy. Reason being that before that the communication to far-fetched places was very difficult, and with the advent of telephones it started, then the cable TV and the internet, and I don't know what will come next. So there was a drastic change after uh, in the post-colonial period, particularly in recent 2-3 decades. And do we go forward with universalized, uniform Western notion of privacy? I would say no. We won't go for a universalized kind of privacy. Uh, Reason being that being a colonial society for 600-700 years, even after that, the identity, our identity is there. I mean, be it the Britishers came, but we have not turned into Britishers. But I won't be very, rigid to that, because the notions will change. The way society is changing the way we are interacting with the other other parts of the world, and the way it is becoming easier. The notions will change with the time, but it will be slower comparatively, as you think that uh, it will be universalized very soon. I don't think so, but yes, in 200 years, 100 years, I hope so.
Thank you so much, sir. That was the last question that we have. Um, I will quickly read out the vote of thanks. Thank you so much for coming on this platform today and for giving such an interesting lecture. I am sure you
Thank.
will all agree when I say, sorry.
I just said thanks for giving me the opportunity to present my thoughts, and wonderful questions were there. It was very thought provoking session for me also. Thank you so much.
Thank you, sir. Thank you. I'm sure you will agree when I say that it has been a great learning experience to hear Dr. Paramjeet Singh speak. His lucid arguments, enthusiastic delivery, and command over the topic, as well as the depth of knowledge, were inspiring. I thank the president of AIRS, Ariba Ehsanat Mausam, for conceptualizing, realizing, and bringing to fruition this lecture. I would also like to thank a speaker for taking time out of his busy schedule to join us and give us this enlightening lecture. I thank all the members of AIRS who have worked tirelessly to make this event possible. We at AIRS are grateful for the support, enthusiasm, and determination of the speakers, participants, and the team at AIRS. Under the unfailing guidance of our president, Ariba Ehsanat Mausam, this event was made possible. Thank you, everyone, for your participation, and thank you, sir, once again for being here with us.